My concerns about the treaty have a lot to do with our military and our sovereignty. We discussed, and you made a very important point, that military activities are not subject to review by these arbitral bodies under the treaty. I have one big concern about that, which is who decides what is and what is not a military activity.
We will decide that. I mean, consider that within our sovereign prerogative.
Where does the treaty say that we decide that and an arbitral body does not decide that?
My understanding, and I'll ask, I guess, my lawyer behind me, that that's in the treaty, that we make that determination, and that's not subject to review by anyone else.
It's not in the treaty, because I'd point you to Article 298(1)(b), where it simply says disputes concerning military activities are not subject to dispute resolution, but it doesn't say who decides what is and what is not a military activity.
No, you're right. In my confusion, I believe that's in the resolution of advice and consent that in 2003, is that correct, that came before the Senate. So that would be a provision of approval. So we would reserve that right as part of our approval of this convention. Have I said that right?
But that provision, which is in the ratification resolution, is our language that's not in the treaty. And the treaty says the treaty is the treaty, and people can't make up provisions that aren't in the treaty. I mean, the fact that we've stuck it in the ratification resolution only heightens my concern.
Could I take a crack at that?
Because it underscores that it's not in the treaty.
With respect to almost all treaties, there are vague terms in the treaties, and if they're not defined, then a country will take understandings as to how it understands certain terms to be accepted, and this is a regular thing that this committee does. So in this case, with military activities not defined in the treaty, it is up to the countries to decide what that is going to mean. And in this case, we are sufficiently concerned that we want to make clear that we decide that we would put that in as a understanding, as part of the Senate's understanding. And this is a very common practice. Almost all treaties that the Senate approves have got some understandings as to what the shared understanding between the executive and the Senate is with respect to particular terms.
Right. My point is that that is our understanding. That is not necessarily the understanding of any other signatory to the treaty. Is that correct?
Can I ask the Admiral make a comment on this behind me, who's our legal counsel? Because I believe there are declarations that are allowed, and this is one of the declarations. And could I have my legal just comment? Because
Sure.
This is a technical but hugely important point. Would you comment first? You can use the mic here.
Senator, you're correct in saying that the treaty doesn't allow reservations to be taken. It specifically says you cannot take a reservation to the treaty, but it does specifically provide that you can make a declaration, and that's what we're going to take in if the Senate approves the treaty. In the resolution of advice and consent, we would make this a declaration that the United States alone determines what is or is not a military activity. Other nations have done the same. When this was debated back in 2004, this was an issue in 2004, and after the debate, the PRC, the Chinese, came in and took a similar declaration and said it's up to them to decide what is or is not a military activity.
Let me rephrase my concern another way. Isn't it true that there would be nothing to prevent another country with a different understanding about U.S. military activities to bring that dispute regarding what is or is not a U.S. military activity to this mandatory arbitral process to which we would be bound?
Senator, they can always try, but the treaty specifically states that parties may opt out of any disputes having to do with military activities. All other major countries have done that, and we would do that.
But if a matter is not a military activity, which is what the disagreement would be about, then it's still under the treaty.
It is up to countries to decide what are their own military activities.
That was my first question. Where does it say that in the treaty?
It's going to, unless an interpretation is contrary to the object and purpose of a treaty, it is going to be up to a country to decide what those terms mean. And this is, in fact, an issue that we've thought about. It's one reason why the administration recommended in the resolution of advice and consent that we be very clear on this point. But I would defer to my I give you the law, but I defer to my military colleagues.
I have limited time, so I want to go on to some other things. I would just say that the fact that this is actually included in the ratification resolution heightens my concern, doesn't lessen my concern, because it underscores the fact that the treaty doesn't say it. We say it.